Welcome once again. My name is Msiment Alex, and today I'm going to take you through the law of succession. Specifically, not we shall not delve so much deep, but just a simple guide on succession, especially in Ugandan jurisdiction. I want to look at the will. Want to look at who can write a will. Want to look at where a will can be kept. We want to look at administration of estates. We want to look at property that can be disputed under a will. We want to espouse some simple things under the law of succession, under the succession in Uganda. So let's first appreciate what is a will. What is a will? A will is specifically a document that provides for the wishes of a person upon his or her death. Wishes of a person upon his or her death, how his property will be managed, how they will be disputed to different persons according to how they are provided under a will. We need to know what can be the wishes, what can be such wishes of an individual which can be included under a will. Like I earlier said, the will provides how to distribute his or her property, how different property of the deceased person or of an individual upon his or her death, such property would be distributed. The will also provides for how to manage the children and other dependent relatives, how different children, different the relatives that they have been depending on that person will be managed. They are all provided for. They are all contents of a will. They are also the will also provides who will manage the property, the heir or what, but who will manage the property. That is what the will provides. Also, the will also provides for how the deceased debts will be managed, who will pay the debts, and how they will be paid, because they must be paid upon his death. That is also one of the things that are provided for under a will. The will also provides for who shall be the customary heir, and where applicable. Of course, it's not a must that you must provide the heir, but the will provides for who will be the customary heir of the deceased property and whatever. So that is also one of the things provided for under a will. The will also provides for the burial-related issues. The burial-related issues, how they will be handled. Some people put conditions how the burial shall be conducted, where the person will be buried. Uh, like those are the things that are provided for in a will. The will further provides for who the executors will be, or who the executrixes will be, who will dispute or who will apply for letters of administration, like that. Those are a few things or some of the things that I can highlight on the contents of the will. Now let's look at who can make a will. Who can make a will? I said I just want to give you briefly the guide to succession. Briefly, the guide to succession. Now, who can make a will? I want you to know that any person of sound mind can write a will. Any person of sound mind can write a will, as long as that person is below the age of is actually above the age of 18. A person who is of sound mind and above the age of 18 can write a will. We are looking at the guide to succession. You need to also note that a person who has hearing impairment, or physical impairment, or speech impairment, or visual impairment is capable of writing a will at the time or during the time that person is normal. If the person is normal today but has an impairment tomorrow, on the day when he's actually normal, that person can write a will. As long as that person is able to do it, he can write a will, regardless of the other kind of impairment. So as long as the person has the capacity or feels for he can do it, then he can do it. So you need to also note that a person who ordinarily has mental illness may make a will during the interval in which he or she does not have the mental illness. I tried to hint on it earlier before that if you have a mental illness, a mental impairment, you also have the capacity to write a will during the time when you are not actually suffering from that impairment, from that illness. There you can go on and write a will. Now, allow me now proceed and guide you on what are the compulsory requirements of a valid will. What are the things that should be included in a will? What are the things that must not miss in a will? For the will to be valid, of course, it should meet the following requirements. One, the will must be in writing. Please note, the will must be in writing. That is, it must not miss. It is one of the major requirements of a will. Uh, you need to also know that another requirement is that a person making a will uh, should be at least 18 years plus, 18 years and above. So that means a person below the age of 18 has no right or may not make a valid will. That is what I'm trying to mean here. So then the person must be of sound mind. Of course, subject to the condition that I earlier mentioned, that at times a person of unsound mind can make a will at the point or during the interval within which that person is able to is actually of unsound mind, of sound mind. That means if you're sound of sound mind today, but tomorrow you are not, then tomorrow you can write a will. So we have these people that he occasionally becomes of unsound mind, then that person can write a will during the time when he or she is of sound mind. So you need to also know that a person making a will should not be under the control or influence or coerced by another person. That means if you are coerced, then you will not provide a better will. You will not provide a valid will because all what you provided for under the will was actually influenced. That is what I'm trying to relate about. Then you need to also know that a person making a will should mention his or her children or other dependent relatives. That is a very, very important that should not miss in a will that you need to take into consideration as you're drafting a will. Or you need to also know that the written will should be signed by both the owner of the will and his or her witnesses on each page. The person that has written a will must sign, and the witnesses must also sign for purposes of making our will valid. Then they must all provide their signatures. Then you need to also know that still at least two people should sign as witnesses of the will. Two people must sign to provide to show that actually they witnessed the signing of the will. You need to know that each witness must sign and write their names and address on each page of the will. You must provide your full names. When I talk of names, I don't mean nicknames or what. I mean legal names and signature. and address must all be provided on each page of the will. If the will has 100 pages, then all 100 pages must be signed and by the two witnesses. You need to know that the witness must be 18 years and above for the will to be actually valid. That is very, very important. Please note that the witness must have seen the maker of the will sign. You can't sign the will. You can't sign on the will that you have not witnessed the maker signing. That means you must be in position to see him or her signing so that you also witness and sign. That is very, very important. The witness should not be the beneficiary of the estate. You cannot witness your own thing. It is actually that is what the law is saying, that you should not be the beneficiary. You should not be the son. You should not be the daughter, or you should not be in position to take part of the estate of the deceased. So if you're the beneficiary, please don't accept to sign, because the law will not will consider that will as invalid. That is what I mean. And the law further, as I proceed to guide you, they are saying that a member of the armed forces or a marine at the sea should not actually sign on the will, should not actually have a written will. That is what we are looking at today. Then let's now look at what property should be distributed in a will. What property should be distributed in a will? What property should be distributed in a will? So you need to know that all the property of the deceased person can be distributed. It's not a must, but it can be distributed, except the residential or the home. Except the residential or the home. For those ones, they may not be distributed. But other property, any other thing owned by the deceased person can be distributed under the will. So let's look at actually the examples of these things that can actually be distributed. We have things like land, we have things like money, we have things like vehicles, we have things like household belongings, we have things like shares in companies, we have things like farms, we have as many things as I can mention. Let's please take a note that the residential home or homes may only be distributed in a will where the deceased has provided a residence actually has provided a residence equivalent of equivalent value or status for his or her surviving spouse. That is why we are not disputing the estate of the home or residential of the deceased person, because he has the surviving spouse, she has the surviving spouse that needs to use that very property as the residence. So, but it can be distributed if you are in position to provide another one equivalent to the same that is being distributed. Of course, a will may be altered by court where the maker of the will fails to provide for his or her beneficiaries, such as the surviving spouse or children. Court can actually alter the will if different persons, different beneficiaries are not provided for in the will. Let's now look at where can a will be kept for safe custody. Who can keep the will? Should you keep it in your home? Should you keep it somewhere, or what? That's what now I'm going to guide you on. Where can a will be kept? So you need to know that a maker of the will can keep it. One, at the office of the chief registrar. That is one of the safest places where one can keep his will. Number two, a maker of the will can keep it at the High Court. The High Court can provide the safe custody of your will. That is very, very important. And then a will can also be kept at the office of the Administrator General. That one can is also provides for a safest custody, safe custody for your will. And then a will can also be kept at the bank. A will can also be kept at the bank, or else the will can be kept with religious leaders or institutions. Religious leaders or institutions can also provide a safe custody for a will. And then finally, a will can be kept with the trusted person, which most people use. But of course, most people in the villages keep it with the trusted person. But it is also important that you must have trust in that person. Not every person will actually safely keep your will. So that is what we are trying to espouse. So let's now appreciate the management of a will. Who should manage the will? And basically, the management of a will. Let's now look at who is an executor or who is an executrix. Who is an executor and who is an executrix. Of course, these are individuals appointed under a will or entrusted to put into effect the wishes in a will. An executor is a mere, the appointed person, but of a mere status. Then the executrix is a appointed person, but of the female status. That is very, very important that you need to appreciate in regard to succession, in regard to management of a will. Of course, you need to also know the appointment of an executor or executrix is confirmed by court, which gives the letter of probate. Because before you manage the property of the deceased, at the moment you are appointed as the executor or executrix, then you need to apply to court for letters of probate for you to be able to start distributing and managing the property. Now, you need to also know that an executor does not have power until he or she is, until actually he is issued with letters of probate by competent court, by court of competent jurisdiction. You cannot tamper with the property of the deceased person, however much you are appointed as executor or executrix, until you are availed with letters of probate. And that is very, very important. So, who appoints an executor or an executrix? Who appoints an executor or executrix of a will? That is very, very important that we need to proceed and appreciate. Number one, you need to know that the maker of a will appoints his or her executors or executrix of his or her will. The maker, the person who makes the will, has all the rights to choose who should administer his property, to choose who should be an executor, to choose who should be an executrix of his property. That is very, very, very important. And then you need to know that the maker of the will may appoint one or more executors or executrices to manage their property or to manage his or her will. That is also very important that you need to appreciate. The executors may be one or more than one. It has no problem as long as they will do according to what he wishes. That is very, very, very important. Now I need to take you to how is an estate where there is a will managed. For example, someone dies but leaves a will, and how is the estate of that individual will be managed. That is very, very important. Number one, you need to know that where a will is valid and an executor or executrix has been appointed, then the executor or executrix can go to court and obtain letters of probate. That is very important. The moment the executor or executrix is appointed and it is confirmed that actually is the one, then he can go to court and obtain letters of probate. That is very, very important. Then you need to also know that upon obtaining letters of probate, an executor or executrix has the power to manage the estate and distribute the property as actually stated in the will. Then the will must be executed within 2 years, within 2 years from the date of obtaining letters of probate. Of course, after 2 years, an executor or executrix should make a report to court on how he or she managed to distribute the property of the deceased. If the executor or executrix of a will is unable to execute a will within the required 2 years, within the 2 years period, then he may ask the extension of the time, of course, from the court of competent jurisdiction. Otherwise, allow me stop here for now. We meet in another video to keep on the track, looking at the guidelines on succession. Specifically, in another video, we shall look at what happens. We shall actually look at the duties of an executor or executrix. We shall look at the what happens when the will does not provide for the executor or executrix, and what happens when the executor or executrix refuses the honor of paying or of distributing the property of the deceased. Otherwise, thank you so much. I encourage you to subscribe, share, and comment. Thank you so much.